where they argue that the public benefit test is problematic. And this has been a recurring argument from submitters to this inquiry, that the public benefit test is deeply problematic or problematic. Was that a similar argument in the UK?
Yes, Joanne Edwardes speaking. There was certainly a great deal of concern voiced, particularly by religious organisations, at the time that we were, the public benefit test provisions in the Act were being discussed, and also when we widely consulted on our guidance. And we consulted on our general guidance on public benefit, which says what the general principles are in law. We also produced some supplementary guidance specifically for religious organisations because they were concerned about it, and also because the law had changed in respect to their public benefit test, i.e. the presumption had been removed. So we did have a very, very wide-ranging discussion with them, and we had a series of in-depth workshops held with religious organisations, and throughout that they did voice those sorts of concerns. They said it was very difficult for religious organisations to demonstrate benefits, and it was a sort of an intangible kind of a benefit that was hard to quantify, hard to measure, hard to describe. What we did in our guidance and in all our discussions was we helped them find a way of articulating what the benefits of religion can be and how they can be demonstrated. And certainly the consequence of all of that, and certainly once our guidance was agreed and published, there were much, much fewer concerns from religious organisations about how they would meet this difficult test. We recently had a workshop with some wide-ranging representatives of all sorts of religious organisations, and in fact now many of them were saying that they found it helpful because it's helped them to find a way to articulate what they do, which shows how they meet this public benefit requirements. And this was also supported by some of the individual public benefit assessments that we did on 4 religious organisations. We did this, say, to demonstrate how these principles play out if you look at an individual charity. We looked at different types of religion, different types of way of advancing religion, and in all those cases, the 4 that we assessed clearly demonstrated public benefit, and we were able to show, you know, in what ways they did that. And so those reports that we published on those assessments have also helped strengthen this idea that actually it's a test that religious organisations can meet and can meet well.
Thanks. The other thing I noticed on your website, that you conducted an analysis of public benefit in the advancement of moral or ethical belief systems. There was a consultation took place. Is that correct?
Yes, Joanne Edwardes speaking. Yes, it is correct. We did this in response to partly some requests that came through during the debate in Parliament. There was a lot of discussion about whether in the descriptions of purposes that are included in the Act, of things that the courts have recognised as charitable purposes, there was a debate about whether the one on the advancement of religion should refer to other sorts of belief systems, so whether it should be the advancement of religion or belief. And that was very widely debated in Parliament. In the end, it was decided that religion meant something very specifically in charity law, and they wished to keep it distinct. But of course, other sorts of non-religious, if you like, belief systems can also be charitable, but under a different heading of charity, and that's the advancement of moral and ethical belief. And we undertook to produce separate guidance for those sorts of belief systems. As a consequence of doing that, however, the people who responded to that consultation felt that the guidance that we produced didn't quite achieve what they would like it to have achieved. It's quite a difficult area of charity law. There's very little charity law to explain what this sort of area means and covers. And trying to define something almost by reference to what it isn't, i.e. non-religious, was not really very helpful, and it's difficult to describe it in the positive and say, well, what it is. we attempted to do that and had the consultation. The response was actually it wasn't helpful in the end, and so we withdrew the draft guidance that we'd prepared, and we will deal with any questions that arise in the context of individual cases.
Do you still rely on the extensive case law that's been built up of over 400 years when you look at the public benefit test?
Yes, Joanne Edwardes here. Yes, we do. In fact, this was retained in the Charities Act 2006. The Charities Act clearly says that the public benefit requirement is still what it means in the common law, except for the removal of the presumption of public benefit.
What's the situation now with some of the main religions? Are they comfortable, or is there still concerns about the operation of the Charity Commission? How has that worked through?
Joanne Edwardes, and certainly our experience recently seems to be that many of the organisations that had been concerned all the way along were no longer expressing those concerns to us, and so it would appear that there's much more reassurance, and I think particularly after we did the public benefit assessment and published those reports. I mean, the guidance itself was very well received when we published that, and that did seem to address a lot of the concerns that had initially been raised, and we were very careful to try and make sure there was a lot of misunderstanding about what the public benefit requirement meant for religious organisations, and in particular a concern that there was a secularising sort of agenda behind it, and it was sort of trying to force religious charities down advancing more secular purposes, and we did an awful lot to reassure religious organisations that that wasn't the case. And we think actually now that our guidance and the public benefit assessments that we've done has given a lot of reassurance to those organisations, and we're no longer receiving the sorts of concerns about it that we did at the start.
Senator David Locke speaking. We've also, as a consequence of the Charities Act 2006, a number of charities that were formally accepted from having to register with us had an obligation to subsequently register. And in the course of the last 18 months, we've actually registered about 2,500, just over 2,500 formally accepted charities, many of which were faith-based, many of which were Anglican churches and congregations. And actually, the feedback we've had from those organisations that have gone through the registration process has been, on the whole, positive. They've found it helpful in terms of looking at the governance of the organisation and also re-articulating what they're established for and how they help their communities. So on the whole, I think the feedback that we're getting is fairly positive in this regard.
Because that's the other argument, that there's a substantial additional burden placed on charities, and I would then assume religious organisations, by the operation of a Charities Commission. Has that been a refrain that you've heard in the UK?
David Locke speaking. I think there certainly is concern that's raised by the charity sector about the level of regulation that they are subject to, but certainly all the research that we've undertaken and that other organisations have doesn't indicate that the Charity Commission is part of that problem, really. It tends to be when you're looking at dealing with the inland revenue with regard to gift aid, or issues raised regarding health and safety and other forms of regulation that affect charitable organisations. On the whole, the feedback and the research that we've undertaken indicates that people think that the regulatory balance is about right with regard to charity law and the Charity Commission. And very much our approach to regulation is one of enabling and supporting the sector, and actually recognising that, as in Australia, much of the charity sector is really very small community-based organisations run by volunteers with very limited capacity. So it's a question of proportionality in terms of your expectations of them. And certainly all the guidance that we've given to organisations with regard to the issue of public benefit is that that sort of proportionality also stands.